Thank you very much. Other witnesses in opposition?
Henry Contreras with California Foundation for Independent Living Centers. We share the views of the ACLU and DRC.
Thank you very much. Comments, questions by members? Senator Monning, and then was it Senator Morlock? Did you raise your hand? Senator Anderson? No. All right, Senator Monning, the floor is yours.
Thank you, Madam Chair. I want to thank the author for bringing this forward and for the engagement of all the stakeholders. I think, and I'm glad it was mentioned, we sometimes get so caught up in the concerns of potential abuses of the system that we lose sight of the fundamental underpinning, which is to protect access for disabled community. And I know the author holds that dear, and I think everyone who's testified today, but for me, that has to be the measuring stick. And one of the concerns I had in an earlier draft, pre the proposed amendments, is seeking to limit the number of cases that a lawyer who perhaps specializes in enforcing the civil rights of disabled community in an arbitrary fashion. And I think as I've quickly reviewed some of the amendments, I know we're not talking about those yet, that helps me get to a point, and I think I'm hearing that from some of the opposition as well, because one of my concerns, and I think it's raised in the committee analysis, which I also think is an excellent kind of framing of the tensions here, while nobody questions the good intentions of seeking these reforms or fine-tuning, my fear is an unintended precedent where in other areas of whether it's enforcing civil rights or rights for protection against toxic chemicals or whatever it might be, because lawyers specialize in that area and there's an aversion to the impacts of that type of litigation, that it could result in using this model as a way to limit lawyers that could bring lawsuits for exposure to pesticides, for example. But that's their specialization. That's why an injured farm worker seeks those attorneys out. So I think surfacing those concerns as we try to dial in, I know there's a genesis of this legislation. I've followed Senator Roth's efforts. I was a supporter of the Steinberg-Dutton legislation, which I know in engagement in the communities I represent with both disabled community and with small business owners, a certain amount of hope rested in that legislation that wasn't necessarily supported 100% by the disabled community. But again, it was an effort to recognize a problem, and the problem being people gaming the system for monetary gain, not with the objective being compliance. And so I think as this bill has become refined and as I've reviewed some proposed amendments, and I want to defer to the chair when and how you want to discuss those, but as opposed to having a set bar on the number of cases an attorney could take, there would be some criteria that would not count towards that total, as I understand these proposed amendments, based on certain outcomes, one of which is measurable compliance, that if the litigation resulted in remedies that inured to the benefit of the public, and I say the public writ large, not just the disabled community who are the immediate beneficiaries of compliance, but I would suggest our public is also a beneficiary of that, that if that were a marker and you measure the result of this litigation was the ramp got built or widened or whatever the issue was got fixed, that a lawyer or lawyers involved in that litigation, that wouldn't count towards a bar of the number of cases they could bring. And I know there's a couple of other examples. I won't go through those, but that one in particular, Madam Chair, I think addresses your primary concern, and I think shared by all of us, is how do we move any law changes, that there's a measurable improvement in compliance, meaning access. And so I want to defer to the chair, but I want to thank the author for trying to thread this needle and identifying what I think would be some good measurements. And maybe I'll withhold further comments until the direction of the chair as to how you want to address these. But I think what unites supporters, but supporters with some reservations, opponents, but opponents with some reservations, there does seem to be a common threshold of how do we create these incentives or measurements that are going to result in greater access and compliance. So this is, I think, the fun part of our work is to be able to bring stakeholders together. And again, I just want to thank the author for what I'm sure have been many hours of meetings and trying to thread this needle. So thank you.
Thank you, Senator Monning. Senator Leno.
Thank you, Madam Chair, and thanks to all stakeholders for, as Senator Monning has expressed appreciation for keeping this moving forward in a very constructive and positive fashion. I do have a question both for the ACLU and for disability rights, that when you say you're confident that amendments will address outlying concerns, are these amendments on paper yet? Are we looking at them, or is this something above and beyond? We have something in Amendment 1 here.
Kevin Baker from American Civil Liberties Union. We believe the definition of the high-frequency litigant reflected in the amendments that I think you're referring to is helpful. We think there are a couple other issues that we've got agreement in concept by and just need to work out some language.
So we don't have any of that part in writing yet?
That's right.
Okay. But that's the commitment that the author has made to the committee. And then with regard to some folks who've already testified, whether it's CJAC or the Chamber of Commerce, with concerns about Section 1, there are amendments that you're working on with them at this point, or where are the negotiations there?
Yes, and when I talked to the chair about doing this hearing, the goal was to bring as little controversy in the bill as possible, and with that, I've agreed already to take out that section. Although I do admit, and that's one of the reasons that we're struggling a little bit with the bill, because unless and until we can deal with that landlord-tenant issue in a constructive way, because so many of the smallest businesses are in a very difficult position with respect to their leases, and there are some leases that ask that small business to indemnify the landlord against any lawsuits or changes with respect to ADA, which is putting the obligation entirely on the party who really doesn't have the means or the resources to deal with it, I think is very problematic. And so I've agreed to take that out in order to bring as little controversial a bill as possible. I will admit that has absolutely frustrated DRC. We put that in after extensive negotiations and discussions with ACLU and disability rights, because it's a glaring issue that absolutely needs to be addressed. And when we met with the landlords lobbyists months ago as we started this process, there was an admission, and I think you heard from the folks who are concerned about that section, we do need to do something there. I think it's sort of beyond what we're capable of doing right now in this moment, which is difficult, because I would have liked to have been able to address that issue. It remains one of the large glaring issues.
To what degree can the ADA itself be informative in this particular conversation? Who is responsible under ADA, under federal law? I can't imagine that it's the small business that's leasing.
It is, and then it also depends on that lease agreement. Because if the small business,
left to the
lessee has
lease.
taken on that obligation within the lease, then clearly they're the ones who are liable. And even if there's liability to the landlord, if the lessee has indemnified the landlord in that circumstance, then to the extent that the landlord is damaged, the obligation, the responsibility then falls back on the lessee. this is what we still need to be addressing.
There's no doubt this is really a significant issue. You wanted to speak up,
Just
Mr.
to clarify, if I may, as some of the members has indicated, the ADA imposes liability equally on the landlord and on the small business. As Mr. Stone is indicating, it may be that in these lease agreements, the landlord says, well, legally, yes, I am liable under the ADA, and I'm going to now transfer my liability to you that you've agreed to take on contractually. So that, I think, is the imbalance.
That's the issue.
And I think that is a significant problem here, and I'll tell you why. I think we have to address the compliance aspect. If we are going to put a burden on litigants who are suing on this, there has to be, if you will, a little bit of balance. And that's why I think you had this in the bill in the first place. Everybody, if we're giving, if you will, the phrase we like to use, everyone's taking a little bit of a haircut. At this point in time, then, the only people taking the haircut are the disability community that is saying, okay, well, we're only going to bring this particular kind of suit, and we'll be able to, limit those who can bring it. Having in there something that creates a little concession, because this is a problem. Look, if you really care about the small business person who is not the landlord and who is operating on a shoestring to begin with, and there's an ADA problem, and suddenly you have the small business person bearing the burden to comply, you have, again, you've changed that equation, which is something we wanted to have as part of this discussion. So with that in mind, I would like to suggest, and I appreciate your willingness to keep working and not to bring this bill up unless and until I believe we had agreement with this committee. Given the fact that we don't see all the amendments in print, given the fact that there are still issues we haven't quite grappled with, I would like to propose, and I'm going to urge my colleagues, we have an opportunity to keep this discussion going and keep everyone's feet to the fire, which we want to do. We want to get this resolved. We have an opportunity to have this heard in January and to put an urgency on the bill so that it will become effective immediately. And I would like to suggest at this point, given that first issue, taking this out of the bill at this point, to me, sort of creates that imbalance that I think it would be a mistake for us to try to address, given, and as you said, given the time constraints we're under. We aren't necessarily under that time constraint over 2 weeks, but perhaps we are over the next few months. And I would really like to offer that to you as an option and make my commitment to continue with the urgency aspect of this, but to try to find a way to resolve this. In fact, I hear the Chamber's position, unless I got it wrong, slightly different than the CJAC position. Maybe not, but let's try to figure out a way that we can address those bad actors and also address the need to gain compliance. So,
well, Madam Chair, in fact, I think the Chamber and CJAC's positions, although they were up on either sides of it, are pretty much identical with respect. They would like that first section removed. They said they're willing to continue to talk about that. And when you and I were talking about setting this hearing, you asked me to take out controversial provisions, and it was because of the opposition that came in from the Chamber and from CJAC. I agreed to do that.
No, I think what I asked is that we remove all the opposition, and I don't sense that we have removed all the opposition.
Well, with the amendments, and what the amendments do is focus on the attorneys, and Senator Monning was exactly correct, that when we're looking at the litigants, what we're counting towards that high frequency number would be actions that don't end up in a positive result. Again, focusing on the actions of the attorneys rather than the fact of the lawsuit. And so if there's a judgment entered on behalf of the plaintiff, if there's an access violation that was remedied because of this, again, where those suits are successful, those will not count, because what we're going after are the attorneys, the litigants that are filing a whole bunch of suits without trying to seek or without actually getting any result. Now, that does happen, and especially with civil rights, if somebody sues and maybe loses that, the fact that that happens from time to time within a law firm or for an attorney isn't necessarily going to give rise to the effect of this bill unless it happens often enough that it's pretty clear that that's the business model that's being engaged in that circumstance. And what with the ACLU, what we're talking about would be like public interest law firms and all that, taking those off the table, because those are the groups who are out there truly fighting for those who need us to be fighting for them, so that they're not going to be worried about this bill affecting their ability to step in and do it. So I really think that we have, within the framework that we were handed and the discussion that you and I had, taken out the opposition, we're in a place where I think we do have agreement that we can move forward. That's my commitment. I would still like to move it out of this committee today if we can. It still has to go through a probes. And my commitment that because we're so close, if we weren't close, if I didn't think we had a deal here, that we had a bill that we could all agree on, I wouldn't be making this commitment. I would be seeking us to move this to January. But I think we're close enough to be able to make that agreement, and then working with you, Madam Chair, committee staff, and then we would also communicate with your members, show exactly what that agreement is. Without that, yeah, I won't take it up off the floor. So we do have the opportunity to continue to work the bill.
Senator Leno.
Madam Chair, with full respect of the suggestion you just made, slight variation, which could potentially result in the identical of your suggestion, which is there's something to be said, and I think as authors of bills, we've all been in a situation similar to this, something to be said for momentum, and that if we were today to decide that it's a 2-year bill, the foot comes off the pedal, and it'll probably get going again in September or October, November. I think there's something happening right now that with the author's complete agreement that unless this resolution is clarified, put into language, and determined within the next week, as it leaves appropriations, that it's not going to come up for a vote. And of course, you as chair can always at any time in the next couple of weeks bring it back if you felt somehow you weren't being honored. And we would support you in that. So maybe we do want to give it another week, 10 days to see if it can get there. And if not, by nature, it's a 2-year bill.
Understood.
And that's my request. And if it sits in this committee or on the floor, my commitment with you, Madam Chair, is to make sure we work this out so that you're comfortable.
I certainly want to see a bill come out of this that is satisfactory to the goals that, again, have been articulated, that I think all of us have articulated on both sides of the aisle. I'm just concerned that by removing a whole section of the bill, we are not keeping our foot on the pedal, as you indicate. So I would like, I would like you to continue working with all the parties. The removing Section 1, I think, as I mentioned, it creates a bit of an imbalance. There might be some resolution here that we can get the business community to agree on. It could be part of a negotiation. But still,
and if you're asking me to make sure that in the amendments that we're moving forward, that we address that we take the chamber and CJAC and the grocers up on that discussion at your request, I'm happy to do that.
I would like to see that rather than just throw it out. Let's see if we can come to some agreement. Continue working with the disability community. I think you know their concerns, as well as the ACLU and the members here. So with that understanding, that this bill will not go to the floor without our agreement on this. And I do want to encourage you to keep working on this.
I hope it gets to the floor. I agree. I won't take it up on the floor.
Correct.
It stays a 2-year bill on the Senate floor. We can then have time to work it out if we can't get that last little bit done.
Okay. With the understanding, we're going to keep going, keep trying to work on all these. I don't want to take anything off the table just yet. Let's see if we can't get some agreement.
I hear you. Thank you.
And with that, the chair will entertain a motion on the measure. Moved by Senator Leno. If you would like to close, Mr. Stone would be happy to have you do that.
Thank you. I ask for your aye votes.
Very good. All right. All debate having ceased, the motion is due pass to appropriations. Please, do we have a motion by Senator Leno? Please call the roll.
Jackson?
Aye.
Jackson, aye. Marlock? Anderson? No. Anderson, no. Hertzberg? Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wachowski? Aye. Wachowski, aye.
4 to 1. That bill has sufficient votes. We'll hold the roll open very shortly. Thank you for your hard work on this. I look forward to working with you further. And thank you for all who've attended. We're going to hold the roll open for 5 more minutes. We can do that. Let's call SJR 18. Please call the absent members.
Hertzberg? Wachowski? Aye. Wachowski, aye. 6-0.
6-0. We'll leave that on call for 4 more minutes.
Sorry, guys. Apologize.
No problem. No, understandable. All right. Last call on this hearing date. We are going to lift the calls on the 2 measures that are yet before us. Madam Secretary, please call the absent members on SJR 18.
Hertzberg? Aye. Hertzberg, aye. 7-0.
7-0. That bill is out. The last bill. All right, this is due pass to Senate Appropriations with a commitment from the author that he will not take the bill up on the floor of the Senate without getting approval for the amendments both in print today and yet to be in print. All right, please call the absent members.
Morlock? Hertzberg? Aye. Hertzberg, aye.
All right, that's 5 to 1. That bill is out. This is we will have one other meeting on Thursday that I'm aware of at this point off the floor, but I want to thank the committee for its outstanding work this year. I failed to do it in our last official meeting. I know there will probably be more, but I want to thank you personally for the great work you've done.
We vote on each individual member of the staff.
We are adjourned.